we have we had a technical challenge. We lost a number of speakers. Nyamuri, can you hear me now? Please unmute Mr. Nyamuri, Cliff. If there's Billy is also asking for the microphone. Please unmute Billy. But even as you unmute, them, the thing that we are trying to speak to today as advocates is much about the rights and how they're being expressed. So what is the way forward as advocates? Do we sit back and watch as demonstrations go on, or are there laws that we can come up with, or can we guide the disappointment and the anger that is out there to be channeled in a proper way that is able to bring results back to the general public that is agitating for results? So I'll give the mic briefly back to Makanu. Billy, you've also been enabled. Let me know if you have the mic. Makanu, I'll give you briefly, then we bring Billy.
Thank you. Thank you. Can you hear me, Effie?
Yes, we can.
Yes, thank you. Of course, way forward. The constitution that we are currently enjoying did not come as an easy ride. People had to go to the streets, people had to force the government, and people had to agitate for the reforms. We have seen from the record, the LSK of that time had to join the human rights groups, Kenyans at large, and they had to mount pressure on the government of that time. And I can assure you, the government of that time was much more repressive than the government that we have right now. But eventually, Section 2A of the old constitution was repealed, and multi-party democracy was allowed. And fast forward towards the end of that repeal, there was clamor for the clamor for the new constitution started, and a lot of pressure was put on the government until we got the constitution that we have now. And we are now enjoying, and you can see the liberties that we enjoy. So even today, we as members of the Law Society, we have to continue putting pressure on this government of the day to do things the right way. Because if they do things the right way, we will not have any violation of socioeconomic rights as propagated by Dr. Ojwang. I want to assure Dr. Ojwang that if the government can do things the right way by ensuring that there are no abductions, there are no enforced disappearances of our young people, there is no runaway corruption, you know, projects which are meant to swindle and steal money from the public are not commissioned. You know, the issue of the odious debt is addressed, and that this wanton and runaway borrowing is stopped, so that Kenyans do not feel the heat of unnecessary and runaway borrowing that is not justified. I can assure you there will be no people in the streets, and the socioeconomic rights of those people whom you have said have been violated so far are going to be preserved. So the bottom line is this: the government is the cause of all these problems because it is not respecting the law, it is not respecting the will of the people. Because you have also, Dr. Ojwang did also say that, much as the government may want to give opportunity to young Kenyans, but it's not possible because of the budget deficits and the amount of money that is the amount of money that is supposed to hire these people is not there because of the challenges in terms of generating revenue. The question that I want to pose to Dr. Ojwang is this: how comes the government of Kenya and most governments in developed worlds are very good at stealing money that is meant to serve Kenyans and to serve the public. So if it is possible for them to steal money that is meant to serve Kenyans, it's also possible for them to ensure that they keep aside money that is supposed to afford opportunities. And that is what the young people are asking. So the young people are not going to understand all these kizungu kubwa unless we ensure that we are doing things the right way. And that is our role as law society of Kenya. We have to be consistent and we have to remind the government that if there is a court order that has been issued, you have to ensure that you respect it. You can't be blowing from both sides of the mouth. You want the people to respect the law, but when it comes to your side, you don't want to respect the law. Recently, you saw at the height of demonstrations, the government proceeds to switch off, the television so that people cannot see what is happening, curtailing the freedom of the media. Yet it's the same constitution. They will turn around and tell us that you need to respect the constitution. So we have to continue mounting pressure. And people like Kaluma, who have been elected to parliament to oversight the executive, they need to do that job. Joining the choir master will not save this country. It will make things worse. And we have to measure what we speak. People like Kaluma need to learn that they need to tame their tongues. Because as a leader, when you speak and you whip emotions, people tend to see what you speak negatively more than what you speak positively. So as LSK and as members of this legal fraternity and as Kenyans, for us to realize change, we must continue pointing out to the government that it must do things the right way. And we must remain true to what the law says, because even when a successive government comes in, we will always remain on that straight path, regardless of who comes into office. Thank you.
Thank you. Thank you very much, Wakili. Allow me to now bring the other speaker, Wakili Joshua Nyamori.
Yeah, Wakili, can you hear me?
Yes, we can hear you.
Thank you. Yeah, I feel extremely privileged to be part of this discussion, and especially to share a platform with Mwalimu Ogada, with Dr. Juang, and with Honorable Kaluma. Now, I have listened to Makanu, and I would want to invite him that we climb higher and engage in a constitutional and legal argument rather than engaging in political banter. That one we can leave to Bunge la Mwananchi. Now, I think when I look at the topic that you shared with us, we need to look at reconciling Article 1 and Article 37 of the Constitution, especially the issue of popular sovereignty and the issue of lawful protests. The constitutional framework that defines this is Article 1.1 and Article 37. And Article 1.1 provides that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this constitution. I emphasize the last part, only in accordance with this constitution. And then Article 37 provides that every person has a right peaceably, and I emphasize the word peaceably, and unarmed, to assemble, to demonstrate, to picket, and to present petitions to public authority. The key interpretation point here, in my view, is that Article 1 gives sovereign power to the people, but it does not grant unlimited license to act in any way, to act outside the constitutional parameters. It provides that whatever action that people take in the exercise of their sovereignty must be done in accordance with the law. Article 37 defines the manner in which sovereignty may be exercised, especially when assembling, when demonstrating, when picketing, when presenting petition, to public authorities. And therefore, it introduces the concept of peaceably and unarmed. And it is interesting that when you hear Kenyans discussing this article, they rarely speak about the word peaceable. They talk about peaceful. The word peaceful is not in our constitution. What is there is peaceable. And my view is peaceful would refer to an act, while this peaceable is a concept that includes, the attitude, the demeanor of anybody who wants to exercise Article 37, as to whether in preparation to exercise or during the exercise, their demeanor and attitude is that of ensuring that there will be peace, that they will maintain peace, and they will be unarmed. And that we need to therefore agree that when what is demonstrated would not assure peace, then that particular intended or actual action is not protected in law, is not protected by Article 37, and is not protected by Article 1. And if then it is not protected, then the security agencies have the authority to stop it, especially when it infringes on the rights of other Kenyans. Now, if we look at our jurisprudence, I would want to refer to two decisions. One is in Justice Philip K. Tunoi, and another versus Judicial Service Commission, and another 2016. The court noted that no provision of the Constitution stands alone. Every clause must be interpreted in harmony with the entire Constitution. In my view, this means Article 1 cannot be interpreted as giving license to, acting any way you want, including being violent and engaging in extra-legal protests. Any exercise of people's power must respect other rights and legal obligations. And this includes the obligations to ensure that there is public order, safety, and the rights of others. And therefore, we will need to interpret Article 1 when we mirror it with Article 24, Article 31, Article 238, and so on and so forth. And this, therefore, then takes me to the second case that I would want to invite us to look at, and that is the Njoya and others versus Attorney General and others, 2004, in which the court held that the Constitution does not envisage revolution outside itself. Sovereignty is expressed through legal channels prescribed by the Constitution. And therefore, I dare say that the available mechanisms for the people to exercise sovereignty are in election, in referenda, in recall, in participation, public participation, and any other process that is allowed in law, and that we cannot import what the law does not provide for. For instance, going around burning public property, looting, trying to storm parliament, trying to storm State House as demonstrations of exercise of sovereignty. Now, when we move away from Kenya, we can look at the comparative jurisprudence. And for instance, when you look at the United States, the First Amendment protects free speech and assembly. But the US Supreme Court in United States versus O'Brien in 1968 held that the government may impose restrictions on the time, place, and manner of expression if narrowly tailored to serve a significant governmental interest and leave open ample alternative channels. Thus, even in a liberal democracy like the United States, violence and disruption of public order can lawfully limit protests. I would then again invite us to look at the South African jurisprudence. And Section 17 of the South African Constitution is nearly identical to Article 37 of Kenya's. The only difference is that the South African Constitution talks about peaceful, while our Constitution talks about peaceable. In my view, therefore, our Constitution puts more responsibility on the people who are organizing and participating in protests to demonstrate that the process would be peaceful more than the South African Constitution does. I compare the wordings in our Constitution can compare to the wordings in the United States Constitution and in the Indian Constitution. In South Africa, there is a case, Mulungwana and others versus S and another. It's a 2018 case in which the court upheld the requirement to notify authorities before protesting as a reasonable limitation, affirming that public order is essential to constitutional democracy. It is maybe important to appreciate that South Africa has then enacted a law for regulation of their Section 17 of the South African Constitution, which mirrors Article 37 of our Constitution. And in that law provides a detailed process. It provides that when you want to, demonstrate or undertake procession, you not only notify prescribed authorities, but you have to go and hold a meeting with them, explain to them the number of people you expect, agree with them on how crowd control would be undertaken, and ensure that you provide volunteer marshals to work with the police to ensure that the police and your marshals are able to apprehend anybody who will be going beyond what the law allows for the particular processes of exercising sovereignty. And so when Honorable Kaluma says that it is time that Kenya enacted that law, I agree with him, because we should not allow anarchy to set in under the excuse of exercising Article 1 or Article 37. Now, if you go to India, there is a case called Amit Sahni versus Commissioner of Police. It's a 2020 case regarding the Shaheen Bagh protest. And in that case, the court held that while its citizens have a right to protest, they cannot occupy public places indefinitely and block roads, infringing on the rights of others. And so, you see, when we look at, for instance, what the Indian court held, then it means that the chaos we have been having in this country, when on the day of the protest, anybody can come and do anything that he wants in any part of the city and any part of the country, is therefore then not protected by Article 37. And when I speak as somebody who spent almost 20 years in the streets, and therefore, and I know that when we were engaging in protests, we would take time to train the people that, the people, the mobilizers that would mobilize people. We'd ensure that we have marshals, and we'd ensure that we train the masses on active nonviolence ways. Now, therefore, in my view, when we look at the policy and legal balance, the state has a duty under Article 238, that is on national security, to protect life, property, and sovereignty of Kenya. And therefore, the duty that the state has under Article 238 is not subordinate to the duty to allow people to picket or to assemble or to demonstrate in any way. Organizers and participants therefore also bear a duty to observe legality, ensure peacefulness, and cooperate with the law enforcement agencies to prevent hijack of the possessions by criminal elements, either amongst themselves or by others. And in my view, the word peaceability would apply even if third parties then infiltrate an otherwise peaceful procession. And if that happens, then the law enforcement agencies have a duty and authority to stop that session so as to avoid breakdown of law and order. As I conclude, therefore, I would want to say that sovereignty is not equal to license to lawlessness. And we should train our young people, our young brothers and sisters, and our sons. My son is now a Gen Z, that I have a son and a daughter who's a Gen Z, that they must exercise their rights, but they exercise them in accordance with the law. It would be a tragedy that we leave a generation that would go back to the state of nature, in which life was short, cruel, and brutish, and walk away from the reason why we have grown norms and why we have constitutions and why we have civilized societies. Article 37 is not absolute. I would want to convince this session to that. It is subject to Article 24 and must be exercised within constitutional and statutory limits. I also argue that a statutory framework for regulating public demonstration, that is notice, liability, routes, numbers, and so on and so forth, should be put in place and enforced. And it has happened in South Africa. And you may have realized that in the last few years, the demonstrations that were very violent in South Africa have nowadays become peaceful. And so that you'd see Malema having very huge processions and very huge rallies, but you'd rarely see them turning violent. In my view, police presence alone is not suppression. And so people should not see police presence as suppression. The other day, I was on a TV session in the morning, that was on 25th. And my fellow panelists raised an issue that because they passed through police cordons, Kenya was guilty of suppressing the rights under Article 37. And I told them that as I drove through the same cordons, they never restrained me. They allowed me to drive through, and I could see people walking. But such police presence will always be important to protect the people who are engaging in processions, but also to ensure that other people do not take advantage of such opportunities. I would also then call upon the judiciary, and I'd look forward to seeing from your list of speakers, I was told the Emeritus Chief Justice would be here, that the judiciary must balance right and guard against legitimizing unlawful civic order. And if the judiciary does not do this, then the judiciary, and therefore Kenyans who are the customers of the judiciary, will continue suffering, as we have now seen in the court building that was burnt in Kikuyu and in other places. And you see, today, a few hours ago, I was looking at the video of what happened in Okolao, and I said that we cannot live in such an environment. We have to bring that to an end. Wakili, thank you.
Thank you very much, Wakili Joshua Nyamori. I think you have steered the discussion to where it is supposed to be on what are the rights and how are they exercisable as granted to us. Before I give somebody the mic to weigh in on what you have said, I see one of the speakers has joined us, my council member, Wakili Stephen Mbugwa. Let me take the rejoinders.
Thank you very much, Elfie. And I want to salute you and the team for these wonderful particular sessions you guys have organized as a branch. And there is a continuation of a conversation that is going on throughout the country and in various spaces where Kenyans of goodwill have come together to just have a conversation about what is going on under the rights, under the Bill of Rights, and how the government has, through its particular departments, especially the police department, have been very key in ensuring they suppress the enjoyment of this right. I also want to commend the legal fraternity for how much they have been active, especially the members, in helping and supporting the public. At this time, they need more information on how the Constitution works, on their rights under the Constitution, and how they need to navigate the justice system. I don't know whether there's a chance I need to proceed and make my submission, or it was just an intro part. But
yes, Wakili, just merge them together.
I think mine, in summary, because I'm also in the middle of something else, that's why it took a bit longer time to join the session, is mainly, first of all, to salute all the Kenyans who turned up on 25th and to enjoy and exercise their right, Article 37, the right to protest. And I'm happy that Kenyans have come to appreciate that they do have this right and it is their right under the Constitution. Because for as long as you feel the government is not doing what it's supposed to be doing under their social contract, then I think that's what the drafters of the Constitution anticipated, that in case of such things, we must have Article 37. And that is the time we're able to picket, demonstrate, and express our grievance in terms of the things that we feel are not working, which has been taking a very good momentum in this country. The unfortunate turn of event is how the state, which has the one of the core duties in protecting these rights, have participated in suppressing the rights of people to participate in protest. And I'm taking this even in the view of the statement made by the reckless statement made by the CS of Interior, Wakili Murkomen. And it's so shameful that he's a member of the Law Society of Kenya, and he made that kind of reckless statement that giving the police mandate to shoot and kill Kenyans for even breaching the security of protected areas. Yes, we do agree it's not the right thing to do when you're protesting. People should not breach protected areas. But our members of the police service need to remember that breaching that protected area does not in any way give the police the right to shoot and kill anybody. It just gives the police a duty to ensure they enforce the law by arresting that person and take them through the legal procedure of facing the law for the offense they committed during the protest. Those who stole, they need to be tracked down and arrested. But unfortunately, our police service has turned into a machinery being used by the state to suppress the voices of the people. It's so unfortunate that the police service have forgotten their constitutional mandate, and that's why they are trigger happy to kill Kenyans, to shoot down peaceful protesters, to shoot down even the vendors who are selling their merchandise during the protest. So it's so unfortunate, and I believe and I'm happy that with these kind of engagements on our Bill of Rights and on various articles that provides our rights, especially under Article 37, vis-a-vis the right under Article 1, which is on the sovereignty of the people, and how we can exercise our power, either it's directly or indirectly. And sometimes I want to believe the aspect of Article 37 was anchored on the aspect of that direct participation in the aspect of governance, airing our grievances. And the state must remember that they have a duty to ensure that these rights are enjoyed, because these are aspirations that Kenyans gave unto ourselves, and we cannot in any way imagine that there is situations where they can be taken away, though they are qualified and have to be governed, but we cannot allow the state to misuse the aspect of qualification of rights to now start committing atrocities of killing people across. And I think I will end there and be open to have conversations surrounding this particular topic. Anytime you have an interjection, I can always make one. Thank you very much.
Thank you very much, Wakili Stephen Mbugua, who is also one of the representatives of LSK at the main office. And I note that one of our speakers is intending to leave. Thank you, Dr. Ivan Sugada. We accept that the notice was short. Next time we undertake to give you a better notice. Now, at this point, the Gen Z of a advocates group, a group called Okil Kamaloka, Young Okil Kamaloka, are insisting that they're in the house and they're asking to speak. So Clifford, if you can enable Wakili Chabi Otieno, who is our chair, and Wakili Polikapo Okelo, who are also logged in. They want to weigh in as the Gen Z of LSK. But the question goes back to us as advocates. In as much as people are expressing themselves according to Article 37 and according to Article 1.1, is there something more that we can do to bring a tangible change? Because, for instance, if we look at last Wednesday, this Wednesday, the demonstrations that occurred this past Wednesday, to now the legalese aside, have not borne as much fruit as we would want as a country moving forward. They have instead left loss of lives, loss of property, and destruction. And we can argue that from whatever side backed that loss, you can say the police, as usual, that they over-exercised their powers. And we can say again that the demonstrators came with ill intentions. And that would just be pointing fingers. But is there a way that we can, as leaders, channel this discussion in a proper way, perhaps channeling the anger that Gen Z have, to perhaps bring a petition to their members so that as we march to parliament, we hand over petitions to our leaders and we tell them we are suffering from unemployment, for instance, or we are suffering from corruption in this country, and we are giving you this number of days to present this petition to parliament as our representatives or to the president and come back to us, such that we are exercising the power under Article 101 directly, but we're exercising it in a way that is bringing change or a response, or that is making our country, which is our only home, Kenya, something that we can look back on with pride. At this point, Wakili Polikapo Otieno, please, you have the mic.
Thank you, Effie, and it's quite a good discussion that we've engaged in. I have a question that follows the discussions that Honorable Opondo Kaluma and Nyamori discussed regarding some proposals. And before I can ask the question, I would want to just make a general comment in line with the discussion. And my comment would be that we realize that the supremacy of the Constitution is anchored on the sovereignty of the people. Basically, outside the supremacy of the Constitution comes in the supremacy of the people. So the people in their social contract basically create a document that guides on how they relate or they civilize themselves in various aspects of their lives. So the aspect of the people requiring to exercise their rights has to be looked at in terms of them having the sovereign power. At the same time, the right of peaceful assembly is only possible when other overlapping rights are also protected. And that is one key area that we need to look at. We also need to discuss and agree upon. What are these other areas, or what are these other rights that come hand in hand or aid the exercise of the right of peaceful assembly? For example, what are these rights? I would say we have the rights of freedom of expression. We also have the freedom of association, and we've got the right to participate in political exercises. Now, these three rights come in together, and together they aid the exercise of the rights under Article 37. So these are something that we also need to look at. Is there something, or the rights that are overlapping or going hand in hand with the right of peaceful assembly? Is there any of them being contravened by the state in any way? Because if the state or any other person is not agreeable to someone's freedom of expression, definitely they will not allow that person to express themselves in a peaceful assembly. Or if there is an aspect of association that is not allowed, then that person's right is going to be infringed. The reason why I'm really particular about that person, it's because we need to understand that the right of peaceful assembly or demonstration is a collective right exercised by individual people. It is not a right that comes into play the moment people are en masse. It is a right that comes into play by an individual, but exercised collectively. So we have to ask questions concerning that one person's right of expression, that one person's right to collectively associate with other people, and that one person's right to participate in political exercises. Those are some of the questions we need to ask. When we break it down to the simple element of an individual, then it gives us the right to actually discuss the collective mass. And the final discussion, the final area that I wanted to touch on before I can ask the question is that we need to understand that the protection of the rights of peaceful assembly is also dependent on realization of the broader range of rights. So what are these socio-economic and political rights that we've been able to achieve so far through the exercise of this right, so that we can come and decide whether an individual's conduct in places offers them the protection under the law? Because we also need to also look at what are some of the limiting factors to the exercise of this right. Because in as much as we have the right, we also need to actually realize that this right attracts some responsibilities to it. And that is why we need to also look at the term peaceable or peaceful. The Constitution in itself gives you an obligation as one who exercises that right, peaceful. Before you can proceed and do the rest of it, it has to be, there is a right on it. So those are some of the discussions that I was really trying to bring out in line after Nyamori spoke and brought the aspect of the discussion that most people had overlooked. And before I can go to my question, we also need to understand that the right of peaceful assembly is one of the foundational rights that has given us the ability to recognize or realize some of the rights that we now enjoy today. For example, socio-economic, political. Kaluma spoke about the days when we were having Maandamanos, other people were being arbitrarily arrested. You realize that even the constitution that we are enjoying today is birthed based on the foundation of the right that now we are trying to protect under Article 37. So my question would be, there is a proposal. My question is, there is a proposal that Mr. Honorable Kaluma and Mr. Nyamori have spoken about on how to enforce or how part of the law of Kenya under this constitution. So have we looked at the ICCPR? Have we looked at the General Comment number 37 of the United Nations that is trying to explain ICCPR Article 21, which is similar to our Article 37? Have we looked at those provisions? Have we read the General Comment on how to police assemblies, to the extent that we've realized that they are so insufficient, and therefore we need to actually come up with our own domesticated provision on law? So what is this lacuna that we are trying to cure, that General Comment number 37 of the United Nations and Article 21 of the ICCPR has failed to cure? Because from what I see, there is the element of mischief in trying to come up with such laws, because they would be doing more harm than good. Thank you, Effie, back to you.
Thank you very much, Wakili Poli Okello. I know my international human rights law teachers are yearning to respond to you, and I know Duncan will respond to what you have brought in under Article General Comment number 37, tied with Article 21 of ICCPR. But before he does that, I want to give the space to PLO to weigh in. Mwalimu Ivan Sogada is also in. Mwalimu, I don't know, before you leave, whether you can take Poli's question and just give it a bit more meat before Mr. Duncan also responds. PLO, please.
Hi, good evening. If you can hear me?
Yes, we can.
Thank you, and greetings to all colleagues on board. I've been following through the discussion. It's been cogent. Sometimes it's been getting a bit heated up, but nonetheless, variance in terms of communication and understanding should not be construed to mean that either of our submissions, should be watered down. First things first. When we talk about Article 1 of the Constitution, and of course, vis-a-vis Article 37, well, I've been listening in, especially from the contributions by Honorable Kaluma and Mr. Nyamori. Before we even talk about, limitation of, the right to peaceful assembly or the peaceably, the semantics between those two words, why wouldn't we talk about what precedes those limitations? Why don't we talk about, the ingredients that have made, citizens to go to the streets first to have those grievances addressed? So I'm talking about accountability. And for me, the 13th Parliament has actually abdicated its role in terms of not just representation, but equally in terms of legislation and oversight, because those three faceted approach of bicameral parliament are so key in driving this conversation. Honorable Kaluma, you would agree with me that before the report of the consideration of the Finance Bill 2024 was tabled before the National Assembly, the chairperson of the Departmental Committee on Finance and National Planning went to the House on the Hill and made the quote-unquote concessions through a press statement before the report was actually tabled before Parliament. What does that tell you? That tells you because the executive does not make laws, but the fact that parliamentarians from the ruling party went to the House on the Hill and the chairperson of the Finance and National Planning Committee read a statement to the entire country on the concessions of that particular bill, even before the report of consideration of that bill was tabled before Parliament, tells you there's quite a disconnect between where exactly does the independence of Parliament, begin. And I think that is why on 25th of June, that is when the legitimacy of Parliament was actually watered down. I would say the delegated power of the people to the representatives. I don't know if they're still the representatives, but it is quite disheartening that the representation is not actually seen. So Parliament of today, the 13th Parliament, is more or less like an extension of the executive, because it's hard to decipher between Parliament and executive, because when you make some of these grievances, parliamentarians do not actually factor them in. So how do we draw a balance rather between representation and of course oversight of, on the executive exercise? And the role of lawyers in addressing this is anchored under Section 4 of Cap 18 of the laws of Kenya. And it states clearly that lawyers or advocates need to, assist the government even through legislation. And we've seen a couple of, legislation that are being either tabled before, Parliament. Some of them are too punitive to the common man. And the Finance Bill 2024 perhaps was, just the ticking time bomb. So it has been like a snowball that grows before it completely crashes on the citizens. So my worry would be, how does the 13th Parliament actually redeem itself? Because whatever the Parliament does necessitates these particular protests. And of course, in collaboration with the executive, and accountability, transparency, and our public debt of today, which I think stands at around 11.35 trillion as at March of this year, and Parliament is largely to be blamed on our fiscal indiscipline to begin with. And this has, of course, has the ripple effect on the cost of living on the citizens. And that is why you would see them on the street, because to put food on the table is actually so hard. And when Parliament breached the debt ceiling by amending the Public Finance Act, I think that was the beginning of our downfall. And I can't remember any other statute that perhaps has gone through more amendments than the Public Finance Management Act. And it's so disheartening because our debt stock is actually unsustainable. So we would keep on, borrowing each and every time. So I think, Honorable Kaluma, it will be in our delight if parliamentary, and especially the 13th Parliament, well, I still have that modicum of hope in them. And if you can redeem yourselves in the next 2 years, then we can have a conversation. But as of now, what we see for the 13th Parliament is you don't listen to the people. You may have our intentions at heart, but the instructions are always different. So as I wrap up my submission, I would just like to close by what Socrates once said in an argument against Thomas Hobbes' social contract theory. Now, when the social contract becomes frustrated, then it means there's no argument between the sovereign, who are the people, and the crown. When they say the crown can do no wrong, literally, that is what is replicated in our own system of today. So when Socrates said that he would rather stay in prison and accept the death penalty rather than escape and go into exile in another Greek city, what he meant is, even if he were to go to, say, Kiambu of Durban, or even Garissa or wherever, that burden that weighs on every Kenyan will still be on his shoulders. So it will be my humble submission that we rewrite our narrative, that you as an advocate, Honorable Kaluma, and of course you have so many of your colleagues in the 13th Parliament. How do you restore the trust that has been eroded? And how do you bridge the gap, that has been widening each and every time between the parliament and the citizens who are the ultimate sovereign? With that, I do humbly submit. Thank you.
Thank you. Thank you very much, PLO, the resident speaker with big English. But Mr. Duncan, I know you want to weigh in on what PLO and Polycarp have spoken to, and because much has been targeted towards the National Assembly, we'll have Honorable Peter Kaluma come back in after you finish. Daktari.
Okay, I'll be very brief. One, Nyamodi brought something, Advocate Nyamodi, that right to picket peaceably. Now, isn't it oxymoron that all we hear is the ones who are in the street are angry? I don't know to what extent can somebody be peaceable or peaceful if they are angry. In other words, the Constitution does not give qualification to being in the street and to picket. Whether you are angry, whether you are mad, like a mad dog, whether you have no good reason at all, it's a right you can enjoy. You can come. There is no criteria or a super legislature who check on why you are in street and see whether you are there for legitimate reason or not. So the emphasis on the angry Kenyans are in the street is not necessary in law, or it's not a prerequisite to exercise that right. But it raises to me an issue whether that person who is angry, and so angry as we saw others even saying, I'm ready to die, whether that person can be peaceful. Perhaps one of the qualifications is go to the street before you are angry, because that way you can exercise that right in a way that is peaceful, because it is an oxymoron to be peaceful and angry at the same time. I'm just coming back at this narrative of people are angry. That's not a requirement to being in the street or to picket. And if that is if it's a matter of where to exercise anger, let us find another source in the Constitution, but not the right to picket is not meant for people who are angry or because you are angry. It is because you are peaceful and you have a reason, whether you are angry or not. Number two, when you look at the local context of even the limitation we get in ICCPR and whatever, you know very well that the Supreme Court have defined this element we have of our sources of law, where the international law comes in, and where the drafters made a mistake of even talking of the law of nation, or whether it has become customary law. I think that's what they were talking about, whether it's international customary law. the entire ICCPR has not risen to international customary law. And you know the Kenya Court of Appeal in the case of Mitubel were very clear that our sovereignty extends to our law. And were telling Judge, especially Judge Mumbi, that you are very bright legal mind. This thing of adopting and being adopted by international standard, anything UN, anything, whatever becomes source of law is not proper. And just make our law endogenous and indigenous law. That's the Supreme Court goal. So I don't think that in our local context, the right to picket under ICCPR is even as advanced as we are one of the few nations where the right to picket is anchored in the Constitution. So the ICCPR is way below where Kenya provision is, and therefore the solution must be local. But I think in my conclusion, as I respond, we are mixing both internal self-determination and external self-determination. For me, the right sovereignty belongs to the people. It's really describing right to self-determination. You know that internal self-determination includes voting, includes this constitution coming so advanced to say how to even recall a member of parliament, includes public participation. Those are internal. External means quitting the state and coming with a different country like the one Ndi drew for the region that were picketing that look like a loaf of bread, saying, let's move from Kenya. That is external. That is extreme. And when it is administered under international law, under the Congo case and whatever, it's only extreme. So when we talk of internal, and internal is how to talk to your leaders, including picketing, then there is no so much place for collective responsibility of talking of this parliament that. Because the Constitution has said people can recall their member of parliament. So this idea where we only talk of, and that's where people are represented, but they are representing each individual constituency. Now, the Constitution has even gone as far as giving you how to recall that person. Nobody wants to do that. But we quickly come, as we sing in our SDA church, prone to wonder, Lord, I feel it, of blanket condemnation. This parliament is up to no good. Now, let me ask you, let me give you the best of your argument, the lawyer from PLO farm, that let's give the argument that this is the worst bunch of parliamentarians. Voted by others representing all these other people, constituencies that voted for them, is a bunch of people in the street, better representative of what Kenyans think than that parliament. So that we are saying, as the PLO lawyer is telling us, that the parliament has failed. Now, these people who have come, whether we come from our neighborhood in Kasarani or wherever, 100 of us, and we get to the street and say now because the people like Kaluma have failed, who are voted by the people, who represent the people, and we think they're up to no good. Now, this group of mine from today are now going to come with ideas that are universally acceptable. Who then sit and check whether my idea is more acceptable? Is it in the X space? Is it in the Twitter because I put it in Twitter and I have 100 followers? Is what I'm doing better at representing and carrying the people's voices than the house of the people? But this is the culture of hypocrisy of Kenyans, that we bash institutions. When we want them, we go for them. When we don't want them, we bash judiciary, we bash parliament, we bash the government. In other places, everyone working for government, they start by saying, thank you for your service to us. We are always bashing our institution and reducing it to the individual in there, not knowing that we're actually weakening our mechanism of check and balance, so that we glorify the individual. And as I started, and as they say, when one finger is pointing, 4 fingers is pointing at the pointer. The 4 fingers is, are Kenyans living according to constitutionalism? Are Kenyans living according to rule of law? And the answer is clear, no. Look at the chaos. Even when people come to the street to picket, but quickly it turns to these parliamentarians. There is individual responsibility. Let us not blanket bash the parliamentarians. We have even a right to recall, and let us look at each one, and still at its worst, it is better than a bunch of people in the street telling us, now ignore parliament, we are representing you. Thank you very much.
Thank you, Daktari. I don't see the MP for Homa Bay. I don't know. I think he could have dropped at some point. Please, I see him logged in, but he doesn't have the mic. Mahesh, if you can request the mic, and we'll enable you. And Nyamori, would you please respond to that as we enable Mahesh?
Yeah. Allow me to. Can you hear me?
Yes, we can.
Yeah, allow me to respond to the question or the input that raised the issue of the general comment number 37. In my view, I would start this response by saying that Article 37 is not absolute, and our Constitution provides for that, and that it is subject to Article 34, which allows lawful limitations on the rights of, in a democratic society, for public order, security, and rights of others. And now, when we look at general comment number 37, it does not grant unlimited freedom. It explicitly acknowledges that states may impose restrictions, provided they are, one, prescribed by law, pursue a legitimate aim, e.g. public safety, and are necessary and proportionate. And I think this is what Honorable Kaluma, and this is what Dr. Duncan Ojwang, and this is what I am raising, that we can pursue regulation of the exercise of Article 37 by prescribing it in law, by ensuring that we pursue only legitimate aim. For instance, what we saw on Wednesday calls for actions to ensure public safety. I don't know whether it's true. I just read that the storming of a police station resulted in, death of 3 suspects in a cell. So the other day we were making noise about Ojwang, who sadly died in a police cell, and we are hoping that the people who are responsible will finally be punished according to law. But then here, that hooligans have, for political or other reasons, stormed the police station, set fire on vehicles and on the building, and tried to storm and access the armory. And it has resulted in the death of 3 people who were supposed to be safe in a police cell. And then there is an argument that we cannot prescribe a way of regulating conduct of such hooligans when people are exercising the right to Article 1. So in my view, that right can be restricted. And then the Public Order Act is part of the legal framework. So Public Order Act makes provisions for prior notice, for routes to be approved, and for assigning liabilities. And if Public Order Act, therefore, is part of our legal framework, then it satisfies the requirement of general comment number 37. And these are not violations of any rights in any case, but will be tools to balance freedom with order, which would be necessary for all of us to, exercise our rights. Now, the state's responsibility versus individual rights is something that I believe that we need to look at. And the state's responsibility, the state has a duty to protect all persons, not just protesters, from violence, disruptions, and lawlessness. I listened to the MP for Kikuyu, who is the majority leader, saying that his 105 years old father and 85 years old mother was subjected to harassment, and a crowd went there to, in his words, to murder them, simply because he holds a political view. Whatever view that the MP might be holding cannot allow anybody to use the excuse of Article 1 and Article 37 to go and, threaten the lives of a 105-year-old.
Wakili Nyamori, I think we lost. I might have lost you at the tail end, but allow me to bring in Mahesh.
Sorry,
Honorable Peter Kalu.
Can I just?
Oh, yeah, okay.
1 minute.
Yes, yes.
Yes, I think you may have lost me when I was referring to the DPP versus Ziegler, which is a 2021 case in the UK. It says that the right to protest is protected, but may be limited where it interferes with the rights of others for public safety. And then as I finish, it is also important that we look at the UN guidelines, the US guideline guidance, that is GC 37, which at paragraph 15 provides that organizers are expected to comply with lawful requirements. And then paragraph 84, which provides the state may use proportionate force to prevent violent assemblies or and restore order. And so my view is that the bottom line is that sovereignty is not equal to license for lawlessness, and that the right to protest is not equal to the right to riot, and that Kenya must uphold the rule of law and not mob justice. And to do that, it is also important to appreciate that when the CS for internal security, maybe the way what he said came out may have not come out well, but what the CS was speaking about is in law. It is in law because the police is allowed in law, and we should not teach our children the police is not allowed. Police is allowed to use lethal force in certain elements where the life of the policemen and lives of several policemen were under attack in the last few days. And then when protecting property, when protecting protected areas, including police stations, and so on and so forth. So my view is that we must teach our population their rights, but we must also teach them the obligations that come with the exercise of that those rights. Otherwise, we will be getting into anarchy. Thank you.
Thank you, Wakili Nyamori. Mahesh.
Yeah, I thank you. Sheila. I've been very enriched by the sharing of perspectives on the forum. As I said, the time has come for us to make a law to better secure the enjoyment of the rights under Article 37 of the Constitution beyond the Public Order Act and based on our experiences. And so let me just confirm that I'm keenly listening. I'm happy this conversation is being recorded. I'll be making contact with a number of us who have spoken here, including Brother Joshua Nyamori, has some very good references, which I know will enrich, that law, which, as I've said, must be enacted this time. Duncan Ojuang, Professor Gada, and of course, Stephen Bugu and all other participants. I will listen through to the end, even when I later break. Number two is just to emphasize that there have been several attempts in the past to have a law, guiding the exercise of rights under Article 37 enacted by Parliament. I think the last endeavor was by Honorable Rocco, now the CS in charge of labor. I personally opposed, those endeavors because they were not being brought as bills seeking to limit the rights as required by Article 24, but they were approaching the matter, differently. So let me just emphasize to fellow learned friends that every time I've said I want to pursue a legislative agenda, I've never gone back. We now have the Companies Act, we have the Insolvency Act, we have the Marriage Act, we have the Matrimonial Properties Act, and several other enactments because of the farmer position some of us, including myself, took then in the Justice and Legal Affairs Committee. So this one must be enacted. I dispatched a note to the Speaker yesterday, setting the parameters which I see out of this deliberation we are going to expand. And so let me encourage our colleagues within the Noble Law Society to send views either to me or through the council as we put together the text of the bill, and even later when we go to public participation when the bill is published, because that ideally is one of the things the respective statute. So let us have that, public duty being discharged in terms of, setting the parameters. And of course, I'll be making those references. Number three is just to emphasize that there is nothing Parliament does which can be undertaken without public participation. The courts have already defined and always defined must be meaningful. No single thing can be done by Parliament that does not go through public participation. This is a requirement as a value and principle of governance under Article 10 of the Constitution, and it is also a requirement under Article 108 and 118 in terms of parliamentary procedure. The problem we've had as an institution, and I'm saying this out of experience, is that, sometimes the people in the know do not come forth with information to aid Parliament in making laws or making decisions for posterity in the manner contemplated by the Constitution. There are cases, and I know the Council of the Law Society of Kenya will confirm, that we've even waited for views of individual lawyers and you don't get them. To an extent that in some instances we've had to, write to the Law Society, for the views of the society to be brought aboard. And in a number of those circumstances, we've been enriched by those views. The request I'm making is that maybe we need a committee or a subcommittee of the Law Society that can be more intensely and intricately interacting with Parliament on matters legislation, because all bills being enacted by Parliament or motions are normally notified at first reading, and they are all on the website. So let us, in the discharge of our duty under our foundational act, be giving these views. And I can tell you, I've been in Parliament, in the 11th Parliament, 12th Parliament, 13th Parliament. I can say without any fear of contradiction that comparatively the current Parliament is more engaged than those previous parliaments. Maybe Parliament could be failing on their public relations and in the manner in which they present the undertakings to the public. But I can tell you, this is the Parliament which sits, you remember, like yesterday, we were sitting up to midnight. Every Wednesday, today, unlike before, we sit up to 9 p.m. And you get Parliament engaged, very actively. Look at the legislations and their impacts in terms of number and in terms of their impact to the society, the matters they're dealing with. The number of bills that the current Parliament has been enacting are way beyond double the bills enacted by those, parliaments in each session, in each particular instance. So I want to assuage those of us who believe that this Parliament is any weaker or any lesser or not participatory to, get out of that thinking. Allow me to clarify just one or two issues. One around police reforms. We have units of the police. There is a unit called Critical Infrastructure Police Unit. Those critical infrastructure police unit officers guard our critical installations and offices, including the judiciary, the State House, Parliament, and of course, a number of government offices, taking into account the sensitivity of matters they deal with. Let me not, shy from telling you that anybody who breaches, such guarded institutions in the manner we saw the judiciary, the Supreme Court nearly being put under fire, will give the police the reason to apply lethal force. I don't think we can expect police officers, if we were to speak for the Supreme Court, for instance, to allow people having entered the court and they are violent to wait for them to kill our Chief Justice there. Those are people I can say on this forum without any fear of contradiction that they will find themselves in the arm's way. And I don't think there would be much you would do in the police to, when we talk about the police, let us also be mindful children, our spouses, our fathers, our mothers, people we all know that they are citizens of this country. And contrary to the thinking that because one or two police officers, engage in misconduct, all police officers should be condemned. I'm one person who will, in a detailed manner, having served in the Security Committee for now 13 years, continuously tell you the reforms in the police are apace. And if we have cases of misbehavior or mistake by the police, it must be individual. The larger majority of our officers are very good. Let me say that even on the Albert Ojwang case, if it were not for the intervention of one or two good police officers, we would not be where we are now. So let us not have wholesome condemnation of the entire institution of the security organ called the police. Let us instead hold those ones who go away from the Constitution, the law, and the National Police Service standing orders accountable, and we sanction them expeditiously and adequately. But that is where we are. Number two, we must ask ourselves in the context of enjoyment of the rights under Article 37, that what are the parameters proper? I'm enriched by the definition of peaceably, and I will not want to take the members through it, but I would urge all of us, wherever we are, just Google peaceably, and you'll see how rich and the details. So that the category of people Dr. Ojwang is talking about, when you already say you are angry, really, you are a person who, ab initio, should not be allowed the enjoyment of that right, because peaceably does not contemplate that you are angry even before you invoke Article 37. When you are saying you are on the streets to seek compensation, I'm giving an example for people who are killed, which is a just cause. Should we also not question where, therefore, you should claim, that just end? When you, instead of petitioning the courts or parliament for compensation, you say you are going to occupy State House. When you know the president under Article 31 is the commander-in-chief of Kenya Defense Forces, which are the Army, the Navy, and the Air Force, not the police. And when you know the National Police Service is now an independent service under the sole and independent command of the Inspector General of Article 245, are you still within the remit of the course you are pursuing, or you are now on extraneous, at times even a political course? When you start claiming compensation, and now you are singing things like one time, I mean, where do they interact? And when you go blaming people who are not the institutions that are charged with whatever maladministration you are challenging by way of public administration, like you go saying Ruto must go. How does Ruto compensate somebody who has been killed? So these are all issues we should look at keenly in terms of, in my view, as lawyers. To end, let me just say that we must always remember that in this context we are discussing Article 1. But Article 1 says sovereign power belongs to the people. So who are the people? Is there a section of the population which can define the people? Unless it is a section like a constituent assembly in constitution making, like the one we had at Bomas. Can a section, whether generation or people from a region, define their grievance and decide by themselves without a referendum in which the entire population signifies their position that they are the people, and so if their grievance is not treated in some way, they can seek recourse to Article 1 and Article 37 and do as they will. I would personally disagree with that position, because if we were to accept it, then you need even to look at what we are calling Gen Z today as morphed over time from 2024. The demonstrations we had, the other day, we didn't see the march demonstrations in Homa Bay, which I represent. We didn't see any demonstrations in Migori, in Kisumu, in Turkana, in Samburu, the entire northeastern Kenya, and of course, quite a number of places. Are we saying that those people do not have Gen Zs, or what are we talking about when we want to say that a section now being emphasized by a category of Kenyans calling it Gen Z can do as they will. I think we need to, define things properly. And my view is that where either we don't, as a people, constitute an assembly getting and deriving authority from all of us in the manner, for instance, we constituted Bomas into a constituent assembly for purposes of constitution making. Any, sections of us claiming to be the people could just plunge us into anarchy, because that way you don't have homogeneity, you have heterogeneity, and you have a situation where, the so-called people are not added them in terms of what they are pursuing. So we must, look at those things in that concerted way. But also to say, you remember at the end of the Gen Z demonstrations, which were about the Finance Bill 2024, which was withdrawn. The withdrawal was sanctioned by Parliament. Immediately after that withdrawal, it was now, we are going to State House, we are changing, power. I wanted to say that these rights we have in the Constitution are, to be enjoyed by all, including Kaluma, who is an advocate of the High Court, but has been privileged by, the people to represent them also in Parliament. And let us agree that the enjoyment of all these rights must be looked at as a whole. Our political rights. Currently, I'm in the broad-based government, and I'm not ashamed of it because I made a deliberate decision to be there. So it is no reason for somebody to come to the platform to define for me in which political formation I should, because I also have that as an article, 38 right, just following that 37, my political rights to choose the political formation and not to define for anybody else their political, formation. So let us, move together. Let us always, be collegiate. But as the Society of Lawyers, I want to say that Kenya is in a good trajectory. We just need to be more vigilant. We just need to intervene more. We just need to be very alert. And where we are dealing with Article 37 rights, let us secure that the end is clear. I'm a guy who, from the time I joined university, Professor Kivuta Kibwana, Dr. Willie Mutunga, Davinda Lamba, Professor Kecho Witi, then, created, what we called forces, NCC, National Convention, Executive Council, Clarion, and we started for constitutional clamor. And at that time, we were saying, no reforms, no elections, no constitutional reforms, no elections. You see, even from the beginning, even from the chant, the end is very clear that if there is a constitution, we would not be agitating. When we were demonstrating, when we were in, Azimio up to 2023, we were saying the cost of living must be dealt with, and we were setting out with clarity the end of those demonstrations. When Gen Zs came together, they were saying the finance bill is imposing extra burden on the people of Kenya, and really it needs to be rejected. And so the end is clear. How do we proceed to enjoy and exercise Article 37 rights in an environment where even the end is not defined? And so let us introspect and ask, if you see, for instance, that unfortunate lady whose son died, Josephine Onyango, is moving to the street with the former Chief Justice saying they need compensation. They even says it was promised by the president. Of course, the president cannot compensate because the budgeting authorities in Parliament, and determination of compensation is before the other arm of government. Now, they ran on the streets. They had even to suffer the consequence of those disruptions by whether hooligans or the people who called them, you see tear gas on them. At the end of the day, she went back. Now, absent petitioning, which is another mode in Article 37, where does that place her? And what is the end of it when you just say, people, let us go to the streets, Sirini number, one term, Ruto must go, then the end is not clear. And when the end is not clear, we must therefore have a law which says when you give notice, you will be saying you are going to demonstrate, you are going to protest for such rights, and this is your aim. And so that you can also be guided. If you want this, Article 37 also provides for petition. Why don't you petition this authority on this defined manner, and we move together? Otherwise, let me thank all. I yield back, believing that such platform should always be there so that we share more across, the legal spectrum, fairly as learned friends, privileged to serve the nation in our different ways. I thank you very much, and I yield back.
Thank you, Honorable Kaluma. I hear you in two things. One is that we need synergy between LSK and the National Assembly on even the laws that come up. Several times, advocates will agree that we have seen emails calling for our views in terms of the laws the bills that are before Parliament. But perhaps we should now explore a working committee that advises on the legality of these bills, even before they go on to be debated, and before they now come back for us to go and apply to court to have them struck out for going against something. We can build on that synergy, and it's a conversation as a law society we will be having going forward. The second thing I picked from you, Mhesh, is that we are at a crossroads that demands dialogue on the way forward. Because if we are to go on with our hard stances, for lack of a better word, from the Gen Z side, the hard stance that the government has to yield. From the government side, the hard stance. And if you look at what CS Kipchumba Murkomen was saying just yesterday, the kind of hard stances that each side is taking. And I think all of us have to agree that at some point, we have to yield to agree to what is workable, even as we approach a peaceable position from both sides. But allow me to bring in Freddie. Freddie, you have the mic. Please weigh in, then you'll be followed by Polycarp, who's requested the mic again.
Yeah, Sheila, before you yield, what you say reminds me of a thing, if you'd permit.
Yes, Mahesh.
Yes, I'm grateful to the speakers already nominated for the indulgence. You remember when we ended in 2024 the Gen Z protests, and you remember somebody like myself, I speak with a free conscience because I voted no, and the records are there. We at the end sat and we were asking, now that the finance bill has been withdrawn, what do we do going forward? Has it cured all the grievances the Kenyans went to the streets for? And remember, this street protest started in 2023. And we concluded in a meeting that we sat through for, a whole day, and a meeting which was on television, that really, if we just end here, we would lose much more we would have gained. And so you remember, we sat and called for a National People's Convention. Because we were saying, now that this thing has moved from the finance bill to Kufa driver, Kufa Makanga. If the driver dies and the Makanga dies, the driver symbolized the president has to be removed. The Makanga was the deputy to be removed. Then as a lawyer, what is the posture? And I remember I took a very firm position, and I said, where we don't have the president and the deputy president, we will go straight away into the hands of the Speaker of National Assembly, who can only sit for 90 days. After those 90 days, of course, we go into an election. And then we were faced with the reality that, okay, now if elections is the only thing, then we don't have the Electoral Commission in place. What happens after? After that, it is only the military that can take over. And what they would start with is the overthrow of this constitution with this rich Bill of Rights we had. And so you remember we resolved and we said, let us have a people's convention so that this thing that is being said that leaders are not listening, let us give people a big forum, and we even said the young people would take the first 50%, but we nominate cross-section members of the society, including Law Society of Kenya, so that we can identify, we can go to the underlying cause of this thing beyond the finance bill. And you remember the response then was that we are now traitors, we cannot do anything. I'm happy that now people, even the young people, when you watch them on television, they are saying we need to be listened to. Let us agree in principle that matters which we can resolve on the table, we take opportunities to do so. And let us also agree that in as much as we can, we may not communicate to all Kenyans and communicate adequately and communicate in the manner that is desirable to sections of the society. Really, sometimes our talking together to agree could be more beneficial in terms of our progress, even in the legal realm, than taking antagonistic and rigid positions on things that we can resolve together as a people. So we are back, and I'm happy there is opportunity to talk. And in that opportunity, as I've told you, I learn in every space, and I eternally thank you for involving me on this one. And I think if we can create that forum, then you would realize that most of these things people are complaining about is because it has not been presented to them, so that together as Kenyans we look at how we are. So let us avail ourselves of those opportunities. And I think one thing you could also resolve is that something that involves cross sections of Kenyans to diagnose the state of the nation in a very objective, apolitical way is necessary, so that we separate politics from realities, and so that we secure the space of good governance, even when we engage in political ventures. I thank you very much.
Thank you very much, Hesh. Yes, Freddie.
Yes, good evening. Can I be heard?
Yes. Try to be a little louder. We can hear you, but your volume is so low.
Sorry, I'll try. Now, first, thank you for the chance. Now, to talk about a little bit about Article 1, about sovereignty of the people. In my view, sovereignty of the people is a concept that has three manifestations. That is the power to frame government, the power to choose rulers, and to be involved in governance. Now we ask ourselves, who are these people to frame government, choose rulers, and governance? These are the people. So that if you look at our constitution, unlike the repealed constitution, at Article 1 we have the word sovereignty of the people, trying to say that even before this constitution, we existed. You look at the preamble at paragraph 7, that talks about the people acknowledge their sovereignty. So it says that even before that Article 1, they already exist. Now, if we talk about the power to frame governance, we say that the first one is that when government is being framed, we are designed to be part and parcel. We have to say that we belong, we participate. Power to choose leaders means that then we have the right to vote the leaders we want. So that if today I choose Honorable Pondo Kaluma, and maybe I feel it's not doing well, then the problem is not with him. The problem is with me, who have chosen him. Perhaps I might be worse than him. Now, when you talk about to be involved, it means, as Honorable Pondo Kaluma says, that there is involvement of the people. Then we know that when decisions are being made, the people are involved. Now, when we talk about this idea of the people, how do we interpret this constitution so that we understand even our rights? Now, there's a theory of interpreting the constitution, and I believe Mwalimu Dr. Gada is listening. He may correct me if I'm wrong, that there's a theory of interpreting the constitution that believes that the writer of the constitution must be seen as someone who is not sophisticated. That this particular author of this constitution is an average person. An average person. Another person, just think of most important things. In fact, if you are to ask them of anything, the first thing they will start with is about food. Then the other things follow. So much so that when we talk about sovereignty of the people, it therefore means that it's the principle that is given the most weight in the constitutional provision. Now, looking at Article 37, because we are talking about Article 1, vis-a-vis the demonstrations that we had. Now, Mr. Nyamuri talked about Article 37, and I agree with him when he said that it's not absolute. Maybe what I can add is that that right under Article 37 to picket and demonstrate and even assembly can be protected. The state is not giving it to you, but it can be protected to ensure that it does not infringe or inflict, it does not limit or does not infringe on any other individual's right. As you demonstrate, the other people who are not demonstrating. It doesn't mean that if I'm doing my business, you come and vandalize my business because I'm doing business. I hear some people say that we are fighting for you. Some people may not even understand why. Like somebody was asking me on 25th, why are these people demonstrating? And of course, I was quick to tell them that they understand the reason why they are demonstrating and it's their right. Now, as I said that this is not a sophisticated person. These people think about food to start with. It doesn't therefore mean that if I have a grievance against a particular person or a particular office, then all of us in this space are must join me. No. Now, this Article 37 therefore is subject to limitation in the sense that it is its enjoyment may be curtailed in certain circumstances. Now, just to conclude with, I remember what we were taught about the Grundnorm. Changing the constitution is not a remedy. Changing leaders is not the remedy, because the Grundnorm will always remain. Because we know the Grundnorm is the presupposition of the legal order. So that even if today we were to change the laws or we were to change leaders, the Grundnorm will always remain. Now, sometimes it's our attitude towards these laws so that we do not even have to make so many legislation. In fact, we have forest of legislations. But the question is, how do we respect the rule of law? So that at the end of the day, when we are demonstrating, we are not seen to be curtailing other people's rights. We also let others enjoy their rights. And I think I'll stop there. I do not have much to say. Thank you for the time. And I also thank the previous speakers.
You're on mute.
Sorry?
You're back to mute again.
Where did you lose me, please? Because I've been talking all through. Sorry.
Please unmute.
Yes, Sheila?
Effie, can you hear me? Can you hear me, Sheila? Hello? Am I audible? Hello, can you hear me?
We can hear you.
Okay. As a rejoinder and maybe in conclusion and at some point to agree with the previous speakers concerning various questions that I asked and my friends asked that at some point converged. I'd like to agree to the extent that peaceful assemblies should not be pursued, or as the law is, should not be pursued on controversial goals that would end up causing disruptions or in any way turning violent in any manner. And that is why at the moment there is so much going around whenever we hear there is a demonstration that is going to take place on a certain day, because over time these demonstrations have morphed into something that is not attaining the particular goal that was intended in the first place. So we are not saying that, I am not saying that the government has got some responsibilities that makes it 100% on their side, but I believe that there is another responsibility or on the obligation on the part of those who are participating in these demonstrations. For instance, the controversial goal in this case that we describe as morphed is where we have political objectives being included in the initially well-intended demonstrations. And the moment that we have a demonstration with the clear objective of what it wants to achieve, the moment that has been achieved, then we need to go back and analyze whether the things that have been presented to the table or the things that have been achieved so far are addressing the reasons why we went to the street in the first place. So we've just had the political elements being part of it, and that is why we have seen such kind of reactions at the end of the day. It's not that, I'm not saying that the fact that there are political elements that have infiltrated the well-intended demonstrations justifies the resolve or the actions of the police. No, I'm only saying that peaceful assemblies should not have controversial goals or cause disruptions, because we've had that discussion around peaceable, peaceful. So I agree to that extent. So there is also need, and so far I think we haven't really addressed this issue of spontaneous assembly, which are typically are a direct response of contemporary events. For example, the issue of Albert Ojwang raised a spontaneous assembly. We are still ill-equipped in policing or managing assemblies whenever we have spontaneous peaceful assemblies. And that's why even with the suggestion of Honorable Peter Kaluma that we need to have a system which is in place through the Public Order Act, though it is not mandatory, it does not in any way invalidate any assembly, because the notice in itself is to aid the enjoyment of the right. However, back to the spontaneous assemblies have been ill managed, or the police have so far failed to manage spontaneous assemblies. And that's where it takes us back to the issue of notice. We're in an age whereby the issue of notice might not really suffice. The Public Order Act, looking at the historical events behind the enactment of the Public Order Act, you'd understand why the current state of affairs does not in one or the other favor such kind of regulations beforehand. And therefore, we need to find a way to manage these assemblies that just come about and do not require any form of notice. And just like I said, it doesn't invalidate an assembly if there is no notice issued. And to conclude, such fora, for example, the one that has been organized by the Nairobi branch, is an important step in addressing an important aspect that has so far been overlooked. And this aspect of training of those participating in these assemblies, there is that need, there is the responsibility to train those participating in these assemblies on what is required of them and what is not required of them. The manner and the mode of enjoyment of their rights is very necessary, because like I said when I started off, these rights are enjoyed by individuals. They are not a collective right. They're just enjoyed collectively, but the responsibility falls on an individual. That's why it becomes an excuse for the state agents to claim that there were criminal elements, because these criminal elements are not going to be liable as a group. They ought to be liable as individuals. It means even when we are enjoying the rights to peaceful assembly, these are rights that are enjoyed by individuals but collectively exercised. So what am I saying? I'm saying that there is need to train. There is need to train the people enjoying or participating in these peaceful assemblies. And we also need to explain to them and to demonstrate the meaning of peaceful, peaceable, non-violent, and violent means of exercising their rights. So it is a responsibility that goes back to the state, that goes back to the Law Society of Kenya, that goes back to those people who know better, to ensure that we have such kind of fora where we explain to the people what entails enjoying their right to peaceful assemblies. Thank you so much, Effie, and back to you.
Thank you very much. I don't know whether in winding up, Wakili Nyamori, you'd want to go first, and then the other speaker present is Mheshimiwa Kaluma. I don't know whether you had summed it up, or just have a closing remark as we finish.
Wakili, I want to just say that this has been quite enriching. I was just looking at general comment number 37 of the ICCPR, Article 21. And I note the fact that it says an assembly is a gathering of persons for a specific purpose and includes demonstrations, protests, meetings, processions, rallies, sit-ins, candlelit vigils, and flash mobs. In my view, therefore, is that there's an important aspect here that we need to be able to educate our people on. For you to then have, if you are to base it on general comment number 37, for you to have an assembly, it must be a gathering of persons for a specific purpose. And see, you on 25th of 25th of June, the families of the victims of the last year killings gave a notification that they want to undertake a procession to go and deliver a petition. And so, to that extent, that was an assembly that is protected by Article 37 and that is protected by General Comment number Article 37, but also the General Comment. But then, when other people then infiltrated it, and some said that they want to go to Parliament and occupy Parliament, some want to go to State House, and they want to effect a regime change, then in my view, that assembly therefore lost that protection of Article 37. And these are some of the things that we may need to educate our people on. So I want to conclude by saying I've found this quite enriching, just like Honorable Kaluma had mentioned. I would want to encourage Wakili FE and the Nairobi branch to continue doing this and probably, nudge the other branches to do the same. And through such forums, we can actually undertake proper civic education to our people and ensure that the country can learn its laws and we are able to exercise our rights effectively but responsibly. I am hoping that what Honorable Kaluma has mentioned will come to fruition and that we will all be engaged in a rigorous thought process to make inputs into that legislation so that we have a legislation that will actually help secure the rights, but ensure that the rights are not misused to the detriment of other people and to the detriment of the country. Thank you very much.
Thank you very much, Wakili. Hesh, Honorable Kaluma, your closing remarks.
Yeah, I think we have spoken as learned friends. Let me start by thanking you, Sheila, and the Law Society of Kenya team for putting this platform. By this platform, we have engaged minds objectively, we have shared perspectives, and let me thank you more that in as much as, there have been differences of opinions and perspectives, it has been very cordial, very learned, very engaging, very courteous, and very respectful. The material, of course, we have put together material, I think, that we should, carry forth as we discharge our obligations under the Law Society of Act in public interest and for the benefit of the nation. We will be making contacts. I would be requesting Wakili Sheila that these matters be consolidated, and if you find the time and opportunity as the council, let us, put them together in terms of resolutions, and let us, not, just lose them here. But lastly, to say that Kenya really belongs to all of us, and Kenya is the only state we have. Sheila, in 2023, I was addressing the EU Parliament on the security situation in the Horn of Africa. And I remember when I mentioned what could be done to secure Sudan, the Republic of Sudan better, the delegation from Sudan shouted me down and said they can deal with their issues. When Hatum then, exploded, the leader of that delegation who was shutting me down called me from Sudan and said he regretted what he did. And it happened to be at the time we were having the 2024 June 25th Gen Z demonstrations. And he requested me, he told me just one thing which I needed to end with. That number one, the continent envies Kenya for our rich Bill of Rights. But he said that we envy you. You have a rich Bill of Rights, but don't lose your country in the enjoyment of those rights. And he told me a very painful thing, that when Khartoum, found itself in the situation it is, his home was raided by over 11 soldiers who turned, his own, wife and 2 daughters into, sex slaves, cooking for them and just raping them as he watches there. And that is where I want to end it, that we may differ professionally, we may differ at personal level, we may differ in terms of our political perspectives, but really when it comes to the existence and stability of the state, let us always be alert as lawyers that we can only enjoy the human rights and fundamental freedoms of under Chapter 4 of the Constitution in a framework where, Kenya is stable. And we should, as brothers, not, encourage situations where we destabilize the state. Otherwise, I'm grateful for the engagement. I cannot thank you enough for this platform. And I would request that in future, we also pick other pertinent, topics, and so that we engage. Even for us who are, not just advocates, but also, serving elsewhere, we should have platforms, Wakili Sheila, where you can just call us to say, today we have a platform, we have our members in parliament, we want to know the position on this, we want to know what is on this, we want to know what you are doing for us in this. Because when we were elected, really, the Law Society of Kenya celebrated. There must be a platform at which we engage with our, mother society and report back also to our mother society on, what we see wherever we are. I'm grateful for this engagement, and I'm grateful to all participants for engaging. May God keep you as we go into the weekend. Thank you very much.
Thank you very much, Mahesh. I don't know whether my chair who opened this forum for us is logged in. I seem not to see him. He could have dropped off at some point. But on behalf of the LSK Nairobi branch, in which I represent in council, allow me to thank you, members of the public and members of LSK, for creating time. As ably stated by Honorable Peter Kaluma, we shall be putting this into a resolution, what was discussed, and sharing with our members. We shall also forward the same to you, sir, now that we have your goodwill. Perhaps when we call on the other leaders, we ask that you ask them to also extend the same goodwill to, because they are members of LSK, to at least come and engage with us so that the betterment of Kenya supersedes every other intention. So finally, God bless you all for creating time. God bless Kenya. May you all uphold the rule of law and respect the Constitution, rule of law, and advocate for the public and the Gen Zs. May you also advocate mostly and greatly for Kenya, because that is home. God bless you. God bless the Law Society of Kenya. God bless the country. Asanteni sana for creating time.
Asante sana.
Welcome. Have a good evening.